Good morning, Council. Welcome to the February 10th, 2022 docket of the Kansas Court of Appeals. I'm Anthony Powell. With me today are two distinguished judges, Judge Kim Schroeder, Judge James Burgess. It might be of note that all of us are former district judges. Judge Burgess is a retired district judge from Sedgwick County, and he and I served together on the Sedgwick County District Court bench for many years. This is our second case on the docket, and so I will call that case Webb versus McPherson Contractors, case number 123759. Okay, we have the appearances of counsel, please, and I'll start with the appellant.
Good morning, Your Honor. Mark Middleton here on behalf of plaintiff appellant Darrell Webb.
Your Honors, my name is Randy Forbes with the firm of Frieden & Forbes in Topeka. We represent the appellee McPherson Contractors.
Very good. Thank you very much. We've set this case for 15 minutes of oral argument each side. Mr. Middleton, as the appellant, you have the right to reserve some rebuttal time. How much time would you like to reserve for rebuttal?
Thank you, Your Honor. I believe 3 minutes should be sufficient.
All right, I'll reserve 3 minutes. You may proceed. You have 12 minutes.
Okay. May it please the court. Your Honors, Mr. Forbes, this is an employment matter arising under the anti-retaliation provisions of the Fair Labor Standards Act, so the FLSA. The only claim on appeal here relates to the district court's grant of summary judgment on plaintiff's claim of FLSA retaliation. I'm not going to spend a lot of time talking about the standard, but as Your Honors are aware, when considering a motion for summary judgment, the evidence must be viewed in the light most favorable to the non-moving party. Here, that is the plaintiff appellant. And the non-moving party should get all reasonable inferences, and the court should accept the non-moving party's allegations as true and give him the benefit of the doubt when the assertion conflicts with those of the movement. So the facts of this matter, very briefly, because I'm sure you're aware that you've read them. Plaintiff was hired in May of 2017 to create and develop a human resources department. He was not in legal compliance. He was not doing FLSA compliance. He wasn't doing payroll. He was setting up a human resources department for purposes of benefits and onboarding and things like that. Fast forward to January 23rd, 2018. Plaintiff received an email from his supervisor, CFO Jane Gunn, stating that defendant would not give a former employee, Jesus Mendez, his final paycheck until he returned defendant's equipment. In response to that, plaintiff emailed Gunn and the payroll manager, Tanya Osborne, and said, you know, of course, that is illegal to do in Kansas. On January 26, 2018, so that was 3 days later, the director of operations, another one of plaintiff's supervisors, emailed plaintiff insisting that plaintiff get the sheriff involved in order to recover defendant's property. Plaintiff refused that request. And in fact, he went to Mr. Stuvey's office and he reported to Stuvey that withholding Mendez's paycheck beyond the regular pay period was illegal. And he told Mr. Stuvey that he would not participate in getting law enforcement involved. Then on January 27th, that's the following day, Ms. Gunn emailed Stevie and said, you know, Darrell will not agree to this, talking about the plan of getting the sheriff involved. You know, Darrell will not agree to this. We cannot hold his paycheck as hostage until we get his equipment per the state, but that has never stopped us before. So these emails show not only that they are aware that the plaintiff was opposing the scheme to withhold the paycheck, but they knew that it was illegal to do so.
Well, counsel, is it in fact illegal to do that under the Kansas law?
Well, Your Honor, it is illegal to do that. And I note that in the defendant's response, they frequently discuss that it is legal to withhold it, but it is only to a certain degree. So you're allowed to withhold the paycheck while you're waiting for the return of equipment, so long as your withholding does not drop that employee below the minimum wage. So if they're making $100,000 and you're withholding a portion of the paycheck until they return a laptop, yet when you withhold it, they're still getting at least minimum wage, that's legal. But if you're withholding the entire paycheck, that employee isn't being paid for the time that they worked in the previous week. That's an FLSA violation. You have to be paying them at least minimum wage.
All right. When you originally filed this action, you filed it as a Kansas Wage Payment Act. Is that correct?
That's correct, Your Honor.
And the district court dismissed both of those claims, and then you amended your petition to an FLSA claim.
Not exactly, Your Honor. We had amended the petition prior to the dismissal of the Kansas Wage Payment Act claims. So during the course of
So here's my question for you, is if it was originally filed as a wage payment violation and you didn't recognize that it was an FLSA claim, how is the employer to recognize that they were being presented with an FLS claim?
Well, Your Honor, simply because we filed it as a Kansas Wage Payment Act doesn't necessarily mean that we didn't recognize it as an FLSA claim. Just the plaintiff, as the master of his complaint, can decide which laws to proceed under. And strategically, this would have kept the matter in state court by not including the FLSA claims at the beginning. Throughout the course of the litigation, we realized it probably doesn't make a difference. Let's include the FLSA claims. But to answer the remainder of your question, it doesn't matter necessarily whether the plaintiff, that this defendant rather, was aware that they were asserting the FLSA claim, but it's whether a reasonable defendant would be aware, a reasonable employer would be aware that the employee was asserting rights protected by the FLSA. And in this case, Your Honor, I will submit that the defendant, McPherson, did know that he was asserting a claim for the under FLSA rights, because as I said earlier, Gunn emailed Stevie and said, we can't do this, but it's never stopped us before. So they're well aware that they were doing this and that it was illegal. And a reasonable employer in their shoes would know that these were complaints related to the FLSA. It's minimum wage. So if there aren't any additional questions, Your Honor, I will proceed.
You may.
Okay. On February 3rd, 2018, just 1 week after plaintiff refused to get the sheriff involved, Gunn informed Stevie that President Matt McPherson was just, quote unquote, waiting for plaintiff to mess up. So February 3rd, this is 1 week after he refused to involve the sheriff, we have the president of the company now setting a plan into motion to get the plaintiff out. So this shows that the plaintiff's opposition to the scheme of withholding the paycheck was the motivating factor for terminating his employment. There was nothing set in motion prior to that opposition with respect to terminating Mr. Webb. On February 8th, 5 days later, Matt McPherson gave Sims, Stevie, and Gunn a target date for plaintiff's termination. That was May of 2018. That was the targeted date. Stevie, Mr. Webb, the plaintiff's supervisor, expressed to Sims, the other supervisor, that he was concerned with plaintiff's failure to follow Stevie's instructions of sending the sheriff out to collect the property from Mendez. So we've got all of his supervisors being concerned that plaintiff appellant, Mr. Webb, was not following these instructions of getting the sheriff involved. And Mr. Webb made it abundantly clear that he was not going to get the sheriff involved because that was illegal, and he didn't want to participate in that illegal activity. So he's opposing it. So the FLSA retaliation analysis, it's a burden shifting analysis. Plaintiff has to prove a protected activity, adverse action, and a causal connection. Now, here, the granting of summary judgment, the district court found that plaintiff did not engage in a protected act by application of the manager rule. Now, we will submit that there were protected acts, and we will also submit that the manager rule doesn't apply. The manager rule says it's not a protected activity if the employee complaining of illegal activity was merely performing his job duties. The court found the McKenzie case compelling, but the McKenzie case is easily distinguishable from the facts at hand. In McKenzie, the plaintiff's job responsibilities as personnel director included wage and hour compliance. Now, in that case, the plaintiff's coworker learned that defendant might be violating the FLSA, passed that information to plaintiff passed it on to the employer, said, hey guys, we might be violating the FLSA. We need to watch out for this. There's a potential claim coming. That was her job, and there's no dispute about that. Here, plaintiff's job did not involve FLSA compliance. It didn't involve payroll. It didn't involve ensuring that the company was compliant with the Fair Labor Standards Act. So that's the first distinguishing characteristic, and I think it's a material one, between McKenzie and in our current case. Further, plaintiff here wasn't simply notifying them that there could be an issue coming down the pipe about a potential violation. Instead, he was actively asserting the rights of Jesus Mendez. It wasn't an abstract thought, something that might happen down the road. It was happening right now, and he was actively opposing that conduct. And when the company tried to force him to participate, when Stevie said, no, you're going to get the sheriff involved, do it, he refused. So when he opposed that behavior, and then when he refused his supervisor's request to get the sheriff involved, he is now taking a step outside of his role, and he's taking a step adverse to the company. So the first part of that being that payroll, FLSA compliance, none of that were part of plaintiff's job duties. And because of that, the manager rule doesn't apply. But even if the manager rule does apply, the evidence shows that plaintiff stepped outside his job responsibilities when he opposed and refused to participate in the illegal activity. So here, the court erroneously found that plaintiff did not step outside his job responsibilities when he opposed the violation. Now, interestingly, when the court first ruled on defendant's motion for summary judgment, the court found that there were sufficient factual disputes as to whether plaintiff stepped outside his role. The court said that it isn't comfortable making the determination and that it should be made by a jury. Then, without any additional evidence, no additional argument, the court reversed course and granted the motion for summary judgment. And it's plaintiff's position, respectfully, that the court got it right the first time when she denied defendant's motion and said that this is a factual dispute. It's a jury determination as to whether or not the plaintiff stepped outside his role and with his job responsibilities. So I think it's
Your time has expired.
thank you, Your Honor. I just to wrap up, I think it's a jury question whether or not the manager rule applies. And I think it's a jury question, if it does apply, whether he stepped outside his role and responsibilities. So with that, I will say that he took an adverse role to the company and the manager rule doesn't apply. I'll use the rest of my 3 minutes in response. Thank you, Your Honor.
Thank you. Mr. Forbes, you may proceed. You have a few minutes.
Thank you, Your Honor. Let me suggest respectfully to the court that I believe the determinative question in this case is this. If a director of human resources for a company whose job duties include advising other members of management on issues related to compliance with employment laws does just that and gives such advice to other managers in the form of intercompany communications, is that giving advice, that communication that he is to do pursuant to his job, is that the filing of a complaint for purposes of Section 215A3 of the Act? Our trial judge, Judge Christopher, specifically found, giving the plaintiff all due inferences and viewing the evidence in the light most favorable to the plaintiff, she found that the answer to that question was no. And on that basis, granted summary judgment. We're asking this court to approve that judgment. Now, as the court is aware, Section 215A3 of the Fair Labor Standards Act sets out a fairly small number of activities which are protected activities. The only one that's at issue in this case at all is whether or not plaintiff filed a complaint against the company. Judge Christopher, in her decision, found that the plaintiff's employment position with the company was a key element in her determination that plaintiff did not file a complaint, and as a result did not engage in protected activity, and as a result could not make out a prima facie case, and that summary judgment was appropriate. The plaintiff was employed by my client for about 9.5 months and had the position title of Director of Human Resources. Interestingly enough, a title that he requested himself. As we set out in the brief, included in the job duties for that position were to represent the company in employee termination matters, to advise the company on human resource practices, and to stay up on employment law to ensure the company's compliance with those laws. It is correct that apparently the entire issue of this case revolves around the payment of final check to an employee named Jesse Mendez. He was an employee of he was an employee of McPherson. He failed to come to work. It was determined that he had resigned his job. At that time, he was in the possession of a laptop computer and iPad belonging to the company. The record shows that what the company did is determined they owed him $204.76. They cut a check for that amount, and they sent that check to the last job site he worked at. The record also shows that in February 5th and 6th, emails were sent to him saying, Mr. Mendez, are you going to make arrangements to come pick up your check and provide us back our equipment? When, as Plaintiff's counsel pointed out, in late January, there was a string of emails in which Jane Gunn, the CFO, indicated that Mr. Mendez would be provided his check when he returned the company's equipment. And in response, the plaintiff made the one-line response, you understand, of course, it is illegal to do that in Kansas. That is the heart of plaintiff's claim here. It's important, I think, to recall that the record reflects that in plaintiff's own words, he said that he got involved in the Mendez matter, the matter of his final paycheck, in an attempt to protect the company, because he thought not paying that final check in the normal course of payments was the greatest likelihood of litigation to the company. We would respectfully submit that's exactly what he was hired to do. We would suggest that Judge Christopher correctly found that advising the other members of the company that in his opinion, it was illegal to withhold that last check was the kind of advice that the plaintiff was hired to provide. So as a result, Judge Christopher, relying on the 10th Circuit case in Mendez, determined that plaintiff had not made a complaint. She determined that the Mendez case, and correctly determined that the Mendez case, provided that an employee such as the plaintiff, who had an obligation to advise other members of the company on employment-related issues and provide advice on the legality or illegality of their conduct, was just doing his job. And that pursuant to Mendez, that cannot be a complaint for purposes of the Fair Labor Standards Act. Mendez, or McKenzie, I'm sorry, goes on to advise us that to step outside your normal job duties for someone like the plaintiff, you have to be asserting rights that are protected by the Fair Labor Standards Act. We've also cited the First Circuit case of Claudio Gote, which says activities that are stepping outside the normal job duties have to be an effort to secure rights afforded by the Fair Labor Standards Act. Plaintiff relies on the fact that he was asked to get law enforcement involved in recovering the defendant's equipment. He says his indication that he would not do that is stepping outside, but it cannot be as a matter of law because the Fair Labor Standards Act does not guarantee to a former employee the right to keep an employer's property. So this is his reluctance to involve law enforcement in recovering the company's property was not an effort as a matter of law to secure rights that are protected by the Fair Labor Standards Act, and therefore was not the kind of stepping out which is required to constitute the filing of a complaint against the company. So with regard to that, we would just respectfully suggest that Judge Christopher was actually correct in determining that the plaintiff failed to file a complaint. It's the only protected activity alleged in the case, so there was no protected activity, and so there was no prima facie case, and summary judgment was appropriate.
Counsel, I have a quick question.
Yes.
I have basically the same question I had of appellate counsel. Is it illegal in Kansas to withhold a paycheck and tell an employee to come and get their paycheck and bring the equipment that they owe back to the company?
I believe it is not, Your Honor. And let me expand on that just a little bit. 44.319 that addresses that issue.
Say that statute again. You faded out.
It's 44.319 subsection C. And what the statute says is that subject to another provision, which does speak about minimum wage, that a company can both withhold the final paycheck and can make other deductions from a final paycheck. I believe what the statute is intended to say is that if a company intends to make withholdings from a final paycheck for things like loans to the company or other clothes provided to the employee, that they cannot withhold so much that it gets below minimum wage. But it says nowhere, I mean, it simply says the company can withhold the final paycheck until the employee returns their equipment. It doesn't say you have to write two checks, one for minimum wage and then another for whatever's left when they bring the property back. And the fact of the matter is, Your Honor, that this record shows that the company cut a check for the full amount, sent it to the job site and said, bring us our equipment, your check's sitting there for you to pick up.
That's
So-
the Wage Payment Act, isn't it, counsel?
I'm sorry?
Didn't you Isn't that statute in the Wage Payment Act?
Yes, it is, sir.
That's what I thought.
The Kansas Wage Payment Act. Yes, sir.
All right. My next question is, appellate counsel says it's illegal for to have asked him to seek the sheriff's assistance in the return of the equipment. Is that an illegal act?
Not that I'm aware of. In fact, the plaintiff admitted in his deposition that he had done that before. I know of no statute anywhere that says it's illegal to ask law enforcement to help you recover your property that is in the possession of somebody that doesn't belong.
Thank you.
We do mention in the brief, and I'll mention it briefly here, that even if the court would decide that the activity constitutes a complaint, we would respectfully suggest that it is not the substantive kind of complaint that is required by the Caston decision, the United States Supreme Court decision of 2011. In that case, the court, and that was a case not involving a management employee, by the way, said that any complaint that gains protection under section 215A3 must be sufficiently clear and detailed for a reasonable employer in light of both content and context as an assertion of rights protected by the Fair Labor Standards Act. So the content here, Your Honors, was that he indicated it's illegal to do that in Kansas. The context is he did it as the HR director for the company, giving advice that he was required to do by his job. So we would suggest that on its face, that comment, and even the other ones that he said he made to Mr. Stevie, simply were not something that a reasonable employer would interpret as an assertion of rights under the Fair Labor Standards. And he never mentioned, and he doesn't claim he ever mentioned the Fair Labor Standards Act. And you're right. The First Amendment petition does not allege a claim under the Fair Labor Standards Act. And so we suggest the same conclusion, and that is that if neither the plaintiff, who claims to be an expert in the Fair Labor Standards Act, nor his employer or his lawyer felt that it was appropriate to file a claim under the Fair Labor Standards Act, how is a lay employer to reasonably know that his comments were intended to pursue some activity against the company based on rights protected by that? We make one final argument, and it's plaintiff talks about pretext. The court said in her final judgment, she wasn't ruling on pretext, but as we point out in a prior judgment, she did find that the termination of the plaintiff had nothing to do with the Fair Labor Standards Act. We respectfully suggest that is the law of the case because it was not appealed. The standard for Fair Labor Standards Act retaliation is motivating factor. She found the motivating factor was unrelated, and that we would respectfully suggest is the death knell of the claim. And with that, I think I've used my time and I have nothing further. Appreciate it.
Thank you very much, counsel. Mr. Middleton, you have 3 minutes.
Thank you, Your Honor. Let me jump right into 44-319. This is what I was talking about during my initial argument. When you go to 44-319E, it says amounts withheld under this section shall not reduce wages paid to below the minimum wage required under the Federal Fair Labor Standards Act, 29 USCA section 201 et sec, or the minimum wage required under KSA 44-1203 and amendments thereto. The statute says plain as day that if you're withholding money, you cannot reduce the wages paid below minimum wage. So to answer Judge Schroeder's question, if you're asking whether it's illegal to get the sheriff involved to recover property, no, it's not illegal to get the sheriff involved to recover property. However, it is illegal to do it when you're withholding a paycheck. When the paycheck is being held hostage so the employee isn't getting the minimum wage, that's the illegality.
Well, counsel, I guess I'm having a hard time understanding the distinction. If the company cut a check for this employee and sent it to the job site, which generally construction companies pay, I understand, pay their employees at the job site, how are they withholding the paycheck?
Well, they had already withheld the paycheck. That payday or that payment didn't occur on the payday that it was supposed to have occurred on. So under Kansas law, under the FLSA, payment is due in its normal and ordinary time period. And if it's paid past that date, then A, it's late, and B, you haven't been paid the minimum wage for the time that you've worked. So because this wasn't presented in the customary manner at the time that when it was actually due, it was untimely. But I think that could be a red herring, Your Honor, when we get really down to it, because the fact is he was opposing this conduct and he was refusing to engage in it. That was the protected activity, and that's when the employer engaged in this concerted activity to terminate him in retaliation. Now, Mr. Forbes and defendant have argued ad nauseum, and the court actually considered this argument as well. They keep saying that the heart of plaintiff's claim is this one email, and that simply isn't true. And that shows that the court wasn't considering the evidence in the light most favorable to plaintiff, and the court didn't give the plaintiff all reasonable inferences, because this claim is way more than about one email saying this is illegal to do in Kansas. It's about the opposition. It's about the refusal to participate. So if it were just one email, we probably wouldn't be here right now, because it could be a reasonable argument that that one email was his job. But once after he sent that one email and they demanded that he engage in these activities that would result in a violation of the FLSA, he refused to do that. So this isn't about one email. This is about
Time's expired.
an email and then many, many more oppositions after that.
Time's expired, Mr. Counsel.
Thank you, Your Honor. Just to finish up, the complaint was sufficiently clear. It's well briefed, and I would encourage Your Honors to review that, as I know you have. You don't have to file a complaint for it to be a valid complaint under Kasten. You just have to put them on notice that you're making it. And I would respectfully submit that my plaintiff did that in this case, and he actively opposed and asserted rights on behalf of Jesus Mendez. And I ask that this matter be reversed.
Thank you, counsel. We appreciate your excellent arguments this morning. We will take this case under advisement and we'll issue a written opinion as soon as we can.